Hi, my name is Renee McCray, and I have been fighting as a pro se litigant for over 7 years in the Baltimore City Circuit Court against an illegally filed foreclosure action that was initiated by Wells Fargo Bank. I say illegally filed because Wells Fargo was never a party to the documents that I signed with the original lender, American Home Mortgage, and they refused to provide any factual evidence of their enforcement rights to those documents. When a homeowner purchases or refinances a home here in the state of Maryland, the two most important documents that they sign is the note and the deed of trust. The note is a negotiable instrument, and Maryland Commercial Law Code, Article 3, regulates negotiable instruments. Section 3-501 of that code allows a homeowner to request proof from any party demanding payment under the note to prove their legal right to do so. When I made my request to Wells Fargo sent me back a certified copy of the note without any endorsements and a statement that any documents that I did not receive was proprietary information and that I would need a subpoena in order to receive them. When Wells Fargo filed the state foreclosure action, they filed a copy of the alleged note with an endorsement from the original lender to Wells Fargo. After years of research, I discovered that Wells Fargo assigned my deed of trust to their bank without any authority from the original lender and without the note. The note and the deed of trust must always remain together. You cannot separate those two documents. This action by Wells Fargo was truly a violation of state law, Maryland Statutes of Frauds, and Maryland Commercial Law Code. It was also a violation of federal law, Title 18, Section 335. The video you're about to see is from a deposition meeting where Wells Fargo's attorneys are attempting to have me admit that the document that was presented to me at a bankruptcy hearing and during the meeting was the original note that I signed in 2005. When in fact, and for the record, the document presented to me was not the original note. In the same meeting, the attorneys attempt to switch the alleged note when we went to make a copy. I observed Mr. Hillman attempting to pass to Mr. Barranco a document that had a tear on the last page where the endorsements appeared. The last page of that document looks similar to this. And as you can see, this tear is very visible. Both attorneys admitted on the record that the document they were copying always had a rip on the last page where a staple would have gone over the years. But as you can see from the video, the document presented to me had no tears, rips, or holes, and the staple was intact. These attorneys will say and do whatever they feel is necessary in order to win, even counterfeiting the note. But what is truly alarming is that the state courts are allowing Wells Fargo and their attorneys to get away with their criminal activities. During the entire state foreclosure action, Wells Fargo was allowed to file false and misleading documents into the court record without ever being required to prove the validity of their documents, even after I proved that the documents were not valid. The circuit court would never allow any of the numerous requests that I made for a hearing in order for Wells Fargo to prove with genuine fact evidence the validity of their documents. Congressman John Lewis stated, "When you see something that's not right, not fair, not just, you have a moral obligation to do something, to say something, to speak up and to speak out." Anyone who knows me knows that I have always stood up for what I believed was right. And I feel I have a moral obligation to share the information that I have learned thus far with other homeowners so that they will not fall victim to the false and deceptive documents and the unethical practices that these foreclosing attorneys will use against a homeowner in an illegal foreclosure. This is good trouble, necessary trouble for Marylanders to contact their state representatives and demand stronger foreclosure protection laws so that these mega banks and servicers are not allowed to file false and misleading documents against any homeowner here in the state of Maryland, especially now with the recent coronavirus pandemic, where tens of thousands of Marylanders are facing financial hardship. And I believe, just as in my case, many will be facing illegally filed foreclosures during and after this pandemic. And I also believe that these illegal foreclosures will be filed throughout the entire United States. So Marylanders, now is the time to stand up, to speak up, and to speak out to protect your rights here in the state of Maryland. In a moment, you will see and hear Wells Fargo's attorneys' unethical practices in the following video. Thank you.
Here begins videotape number 1 in the deposition of Renee L. McCray in the matter of Renee L. McCray versus Wells Fargo's Bank N.A. et al. To be heard in the United States Bankruptcy Court for the District of Maryland. Case number 13-26131 and adversary number 13-00710. Today's date is April the 24th, year 2014. The time on the video monitor is now 2:20 p.m. The video operator today is Scott Pickering. This video deposition taking place at the address of 500 York Road, Towson, Maryland. Counsel, please voice identify yourselves and state who you represent.
This is Michael S. Baranco with the law firm of Traynor, Pope, and Hughes. I represent Wells Fargo Bank, National Association.
Robert H. Hillman of Samuel I. White, P.C. I represent Samuel I. White, P.C. and the individual substitute trustees named in a foreclosure proceeding presently pending in Baltimore City, Maryland.
The court reporter today is Barbara Connor of Merle Deposition Services. With the reporter, please swear in the witness.
Please raise your right hand, ma'am.
I affirm, I don't swear.
Do you affirm the testimony you're about to give? The other hand. All right. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalties of perjury?
I affirm.
Right. Can you please state your full name for the record?
Renee Louise McCray.
Ms. McCray, have you ever given a deposition before?
Yes,
How many times have you been deposed?
once.
Okay. How long ago was that?
Last year.
And was that in a civil proceeding?
Yes.
And are you a party in that case?
Yes.
Okay. All right. So, having been deposed within the past year, you have some familiarity with the deposition process. But I'd like to just review some of the rules of deposition with you before we actually get into other matters. First of all, we are videotaping the deposition today, but we're also trying to get a good record of the case through a transcript, and we have a court reporter here who's creating a transcript. And while we are videotaping the deposition, it's important that you verbalize your answers because, for instance, if I ask you a question and you don't respond, or you say mm-hmm or uh-huh, or something that could be interpreted different ways, we won't know what that means, and we want to have a clear record. So, number one, I'd ask that even though we are videotaping, that you avoid responding simply through body language. You should verbalize your answer, whether it be yes, no, or whatever it is, and avoid terms like mm-hmm or uh-huh. Okay, do you understand that rule?
Yes.
Okay. Before we went on the record today, you asked if you could audio record the proceedings today, and I have no objection to that. Is that, in fact, what you're doing?
Yes.
Okay. Now, you attended a hearing in the bankruptcy court on March 20th, 2014, correct?
Yes, correct.
And I was not present at that hearing, isn't that right?
No, you weren't.
Okay. And at that was it prior to the hearing, were you approached by counsel for the substitute trustees and offered an opportunity to inspect the promissory note?
No.
No? Okay. When during the course of that hearing did you look at the promissory note?
When the judge gave me an opportunity to examine the note.
All right. Was that before, or had the court gone on the record, or was that off the record?
I don't understand what you're saying.
Okay. Well, had the judge come out on the bench, and then there were the proceedings being audio recorded at that time, to your
Yes.
knowledge? And did the judge take a break and allow you an opportunity to inspect the note?
What you mean by break?
Did the judge leave the bench, or did the judge?
No, the judge didn't leave the bench.
Okay. In any event, were you handed something to look at by the attorneys that were there?
Yes.
All right. And as I understand it, you deny what you were shown was the original promissory note that you signed back on October 7th, 2005. Is that correct?
That's correct.
Right. And just so I understand exactly what you're contending, is it your contention that what you were shown at the hearing on March 20th, 2014 was some sort of copy of what you signed back in October of 2005, and then it had endorsements that were placed on that copy? Is that what your contention is?
I don't know what exactly was done, but that wasn't a document that I signed on 2005.
Right. Well, what I'm trying to get at is, did you see a signature on that document?
Yes, I did.
Okay, and did that, whether or not that was an original or a copy, do you deny that that is how your signature appears? Is that your signature that appears, whether it's a copy or an original? Is that your signature on the document?
Is that my signature on the document that was shown to me?
Yes.
No, it isn't.
Well, what I'm asking is, if let's assume it is do you contend that what you were shown was a copy of your promissory note? Is that your contention?
It wasn't. It wasn't the original. That's my contention.
Okay. And well, let's just do this now. Were you shown a folder like this at the hearing?
No, she just pulled the piece of paper out of. Had the piece of paper in her hand.
Okay. Now I'm going to take out. Can you take a moment and look at this?
I'm not touching it
Okay. Why is that?
because my fingerprints is not on that document.
Okay. How about if we give you some gloves?
That's fine. This is the same document.
Okay. And when you say the same, that's the document you were shown at the hearing on March 20th, 2014.
Then again, I'm not sure if it is the document that I was shown. She didn't put it in as an exhibit, but yeah, it looks like the document.
Okay. And on the third page there, do you see where there is a signature that appears to be blue?
Yes.
Okay. And whether or not that's an original or not, do you recognize that to be your signature?
No, it's a copy.
Well, is it a copy of your signature?
I don't know, because this is a copy.
Well, you know what your signature looks like, don't you?
Yeah, I do.
You sign, you've probably been signing your name your whole life, right?
Mm-hmm.
You have to say yes or no.
Yes.
And can you recognize your own signature?
Yes, I can.
Does that appear to be, whether or not this is an original or a copy, does that appear to be your signature on that document?
It appears, but that's not the document that I executed on October the 7th.
Okay, let's talk about that. How do you know it's not?
Because it's not aged paper. It's not 8 years old paper. It's crisp, fresh paper, as if it was just printed.
Okay. Any other?
The servicer.
Okay. Again, show you the note. And do you see, we read that part about I understand that the lender may transfer this note. Remember that? And then it says after that, the lender or anyone who takes this note by transfer and who is entitled to receive payments under this note is called the note holder.
And it says entitled to receive payments. Wells Fargo is not entitled to receive payments. That would
That's
be,
your contention.
That's my contention.
Can you explain, if this is a copy of your note and not the original, then how did Wells Fargo obtain it in the first place that it was able to make a copy? Can you explain
You
that?
need to tell me that, because Wells Fargo was my servicer. Now, how they got that endorsement on there, they need to explain. I've been asking for 2 years, and they still will not tell me.
Tell you what?
Matter of fact, they didn't even tell me that they were on that note until the foreclosure proceeding. They kept sending me notes with no endorsements.
All right. Can you explain to me how Wells Fargo could have obtained a color photocopy of your note? If you're saying this is not the original and you're saying it's a copy, then how did it obtain the original with your signature on it?
It hasn't attained the original with my signature on it. So Wells Fargo need to be able to tell me why that document, which is, I'm saying right now, security fraud. I examined that note. That last page was not torn.
Yes, it was.
It was not. What are y'all trying to pull here? That last page was not torn.
Yes, it was, Ms. McCray.
You know,
Ms.
like I
McCray,
said,
I'm not
that's a
playing this
fabricate.
game.
Well, you know what? You need
Ms.
to
McCray,
go
wait a minute.
ahead.
Stop,
No,
stop.
not stop. Nothing.
Go look through the pieces of paper and
That
tell me where it
was
is.
not-
You were standing right here when I
Something
pulled
is
it up.
wrong with you two. You have ripped that last page. That's not what was shown to me. And that last page was not ripped.
It was.
Oh, wow. You know what? You take it up with the judge. You're playing games,
I'm not
and I'm going to
playing
let the judge know that you're playing games. I don't know what y'all trying to pull here. You're amazing. The last page was not ripped.
Why would we do that?
I don't know. But that last page was not ripped.
Do you want these copies?
Give me the copy. But that last
not-
page was not ripped.
Well, we're not done with all the other pages that you want.
This is
Here,
amazing.
Bob, here's the...
This is amazing.
This is why we asked you to come with us.
You know what?
What?
You're amazing. So if it was, you can't even get the stapler in there. You're wow. You can't even get the stapler in that hole. Now you lining it up. You know what?
Show me
I don't
what the
know
problem-
what.
Show me what the problem is with the piece of paper where the fair is.
This was not
What
there.
was okay? What? Okay, now answer me this
I
question.
examined this
There is
twice.
there is the staple. That
I
went through right
examined this
here.
twice, and that
Okay.
hole was not on
Mike,
that piece of
I want you to
paper.
see what I'm doing.
No, why even
no, no.
staple it? Why even staple it? Just because then she'll
Yeah,
claim it's
don't
been
even
altered.
staple it no more, because, you're amazing. I just examined
I'm
that
not gonna have a
today,
conversation.
and it didn't have a hole in it. Wow.
These didn't collate, did they?
Probably not. But I don't think they're in any particular order anyway. You want the excess copies, Ms. McCray?
No, I don't.
I want to make sure.
No, I don't. No, I don't.
Because I want you to look and see if there's any piece of little paper.
Did you turn that? No, because that page was not
I want you to
ripped.
see.
Is there some reason you think we would tear the corner of
I don't know what's going on here, but I just examined it and it wasn't ripped. It wasn't ripped on the March 20th hearing either.
Well, I actually specifically recall
That it was.
that it was exactly like it is now, so.
I'm glad you recalled that because it wasn't.
Well, good, bring it up with the judge.
Wow.
I guess she'll take your word over the word of two officers of the court.
Well, you
That-
know
that we
what?
would-
Since
that
he
we would
puts fraud in the court, I
I'm a-
guess they do. They will. Yeah, since he put fraud in the court.
There you go.
Thank you.
We're gonna